In this video, we're going to look at the Theft Act of 1968. We'll begin with the definition, which comes from Section 1 of the Act. It's a person guilty of theft if they dishonestly appropriate property belonging to another with the intention of permanently depriving the other of it. And this is a trivial either way offence with a maximum of 7 years imprisonment. You should outline it in your essay. Now, the actus reus is split into three sections. We've got Section 3, 4 and 5. The mens rea is noted in Section 2 and Section 6. The first element of the actus reus comes from Section 3, and this is appropriation. Now, appropriation is usually to take, but the defendant under Section 3.1, the defendant must have appropriated something. This is any assumption of any of the rights of the owner. This can be an outright taking, or it could be borrowing and keeping, and so on. Now, possibly then, it could be an appropriation can occur where the defendant comes by the property innocently or not, without stealing it, but later steals it. A person can appropriate if they assumed the rights at a later date by keeping with it or dealing with the property as its owner, and the appropriation can take place even with the consent of the victim. The key cases there are Morris, Lawrence, Gomez and Hinks. Section 4 deals with property. Now, property is part of the actus reus and of course must be money or other property such as real property, personal property, including things in action and other intangible property. Now, some issues which may come up but don't always come up are things like Section 4.2 where land can't be stolen, but there are exceptions as listed on there. Section 4.3, wild mushrooms, plants, fruit and foliage can't be stolen unless it's for commercial gain. Section 4.4, wild animals can't be stolen, which unless they've been reduced to possession or captivity. Now, key cases there are Kelly and Lindsay, Oxford and Moss, Akbar, Welsh and Edwards and Stacey. The final element for actus reus comes under Section 5, and this is that the property must belong to another. Now, Section 5.1 tells us property can belong to any person who has possession or control or proprietary interest, and that is ownership. Remember also that the property can belong to more than one person at a time and can belong to the defendant themselves in addition to the victim. Now, other issues which may come up are Section 5.3, where a person receives property and is under an obligation to deal with it in a particular way, for example, money. Or Section 5.4, if property is received by mistake, it belongs to another, if you're under a legal obligation to give it back. And your key cases there are Dyker Monroe, Turner, Wayne, Gilkes, and the Attorney General's reference number 1 of 1993. So moving on to the mens rea now. This is dealt with under Section 2, but usually by common law 2. So under Section 2.1, a defendant is not dishonest if he has a right to the item in law, if he would have had the other's consent had he have asked, or if the owner of the item cannot be discovered. Now, usually in an exam, none of these exceptions apply, so we need to look at the Bartle and Booth test, which must be considered. Now, this one test, are the defendant's actions dishonest by an ordinary standard? So this is an objective standard, usually of the reasonable person. Your key cases for dishonesty are Bartle and Booth, Holden and Small. And finally, for the last element of mens rea is intention to permanently deprive. Now, under Section 6.1, a person must have the intention to permanently deprive the other of the item, and this is an intention, and where its goodness or practical value must have gone from the property. Now, borrowing is not theft unless it's for a period and in circumstances making it equivalent to an outright taking or taking value from it. Our key cases there are Vellamile, DPP and Lavender, and Lloyd. Now, the best thing to do is, of course, explain and apply in an interleaving fashion. You'll have a different way of doing that, but making sure each of these is dealt with in turn, and actus reus first, mens rea second. To do this, we need to consider each one in turn. So for appropriate, what we're looking to do is to say exactly how the property has been appropriated, explain what rights of the owner have been assumed, and outline did the defendant come by the property innocently or not. Now, that last one might always be applicable, but the first two certainly are, and then we support with the case law. And next up is property. We say exactly why the thing is appropriated and why it's classed as property, and if it is, what kind. So if it's money, it has to be cash. If it's real property, that's things like land, things in action, other intangible property, but of course most will be personal property. Outline exactly why that is. Again, support with cases. Next up, we have to outline why it belongs to another. So, is it that they have proprietary interest in it? Do they have possession, control? Do they have an interest? But remember, it can belong to more than one person at a time. Outline all of those issues and explain why in the scenario that's been met. Now, it could be that it was supposed to be used in one way, but was used in another. Explain why that is the case and why it would be belonging to another. And of course, if the property was given by mistake and not given back, outline why that still would be theft. Once we've established the actus reus, we need to move into the mens rea. Now, dishonesty essentially comes in two parts. So the thing needs to be done dishonestly, but we need to look at those exceptions for 2(1)(a) to c first. So identify if the person has a right to deprive the other of it. Does he believe in the other's consent, or it can't trace the owner of the item and has taken reasonable steps? If that's the case, outline them. The second is, of course, is he obviously dishonest? Now, apply the Barton and Booth test. We need to look at this idea of, was he objectively dishonest? So what would a reasonable person think in those circumstances? Outline that. And again, support with case law. And finally, for the mens rea, we need to have intention to permanently deprive. As we've seen, we need to make sure that the defendant intended to permanently deprive. So in what way did that happen? Not forgetting that it must be specific intent. So it needs to be not conditional intent, for example, and just explain how did it happen. So did he dispose of it regardless of the other's rights, or did he borrow and lend it and then keep it? Be very specific, support with case law. And of course, the final thing you need to do is outline, are they guilty, not guilty of theft, or was a jury likely to think, and outline the potential sentence.